Can you all hear us? I don't know if they can hear.
Yes, we can hear you. Yes.
Okay. All right. Thank you.
Hello, everyone. I'm Augie Napoli, President and CEO of the United Way of Greater Cleveland.
I'm Danielle Sidnor, President of the Cleveland branch of the NAACP. Together, we are honored to present to the community this series of community conversations on the Cleveland Consent Decree. Each session will focus on an area of the consent decree and police reform through a conversation among experts and community leaders to provide insight and to re-engage the community.
The objective of these conversations is to provide a forum to raise awareness and increase community engagement on the consent decree and how it affects members of our community. United Way's mission is being a voice for those in need. We know that there are so many underlying aspects of poverty which are hard to see and equally hard to discuss and solve. And certainly systemic racism is a main contributor to generational poverty that has afflicted our community for far too long. Not one organization can solve inequity, and I am humbled to be only a small part of a group of esteemed community leaders from whom you will have the privilege to hear in this series.
For 108 years, the Cleveland branch of the NAACP has worked to improve the political, educational, social, and economic status of minority groups, to eliminate racial prejudice, and to keep the public aware of the adverse effects of racial discrimination, and to take lawful action to secure its elimination. This community conversation and the monthly topics we will address related to the Cleveland Consent Decree are right in line with the work our organization has addressed and championed every day for over a century right here in Cleveland. Through this series, you will hear about the current status of the Cleveland Consent Decree and the future of policing in the city. And as the name of this event suggests, this is a two-way dialogue. We want to hear from you tonight and every month in this series as we tackle these various topics.
I'd like to thank Cuyahoga Community College and Rockwell Automation for sponsoring and making this series possible. I would also like to thank the City Club of Cleveland for partnering with us in hosting the series of events, and WOVU for simulcasting this evening's discussion live on 95.9 FM. We'd also like to thank all of our community partners.
Good evening, and thank you for joining us. I'm Helen Forbes Fields. Tonight's topic is search and seizure. The consent decree mandates that the Cleveland Division of Police, or CDP, conduct all investigatory stops, searches, and arrests fairly and respectfully as part of an effective overall crime prevention strategy that takes into account community values. And the CDP will continue to limit vehicle pursuits to those in which the need to capture the suspect outweighs the danger to the public. This language comes straight from the Cleveland Consent Decree. And tonight's conversation will review what has been done to accomplish these goals and what work still remains to build the trust within our community. Tonight's moderator is Lee Fisher, the Dean of the Cleveland Marshall College of Law at Cleveland State University. Lee has served as the Attorney General, Ohio Lieutenant Governor, Director of the Ohio Department of Development, Chair of the Ohio Third Frontier Commission, a state senator, and a state representative. He has also served 4 years as a charter member of the Cleveland Community Police Commission and President and CEO of the Centers for Families and Children. I'm honored to introduce tonight's conversation moderator, Lee Fisher. Lee.
Here we go. Thank you very much, Helen. And I want to thank you and Augie and Danielle for everything you've done for Cleveland in this series. A special thank you to United Way of Greater Cleveland and the Cleveland branch of the NAACP for inviting me to moderate this critical discussion. And thank you to the City Club for hosting this series of events and WOVU for simulcasting the evening's discussion live on 95.9 FM. WKYC Channel 3 is live streaming this discussion tonight, and WOIO Channel 19 on cleveland19.com. Now, by the way, tonight the weather is not very good, but we're expecting a record audience because you can't go anywhere. And if you were going somewhere, you're headed back home right now. So in that respect, perhaps we'll have the largest audience we've ever had. A little warning though, just in case your internet goes out, most of you probably have literally a hotspot on your phone. Just check the settings on your phone and you'll be able to have it as a backup just in case. So that everyone understands how we'll interact as a community this evening. We'll begin with questions that I prepared for the evening conversation. Then at about 7 o'clock, there will be a public question and answer segment when questions from the community will be heard and shared with our panel. And you can start asking general questions at any time during the evening's program. And we're going to make every attempt to get all those questions answered. So you ask, how do I ask my question? Here's the answer. You text your questions to the following number, 216-307-5632. Let me say it again, and I'll say it a few more times tonight. You can text your questions to 216-307-5632. And we'd appreciate it if your questions are respectful and help to advance the dialogue. Now, as Helen Forbes told you, tonight's topic is what we call search and seizure. And I've been asked by United Way and NAACP and the panelists to just say a few words about search and seizure so you understand the background. This is something that we give to each of our students at Cleveland Marshall College of Law at Cleveland State University. What is it? It's a pocket constitution. So let me read to you one of the most important amendments to the US Constitution. It's known as the Fourth Amendment. And here's what it says. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. It goes on to say that, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, that was written in 1791. They couldn't contemplate all the issues that would surround search and seizure in the coming centuries. What does that Fourth Amendment mean in plain language? It means that people, as well as their homes and papers and possessions, such as their car, can't be searched or taken without a good reason, Warrants can only be issued when there are grounds for suspicion, and they must describe the places to be searched and the people and the objects to be taken. There's been a lot of focus in recent years on police stop and frisk practices and whether there is racial disparity in who is stopped and frisked. One more word, and then we'll introduce our panelists. There's a very strong Cleveland connection to the Fourth Amendment. Why? Because in 1968, the US Supreme Court decided a landmark case called Terry versus Ohio. That originated right here in Cleveland, when a Cleveland police officer stopped and searched 3 men at 12th and Euclid. One of those men was John Terry. The Supreme Court held that the Fourth Amendment prohibition on unreasonable searches and seizures is not violated when the police officer stops a suspect on the street and frisks him or her without probable cause to arrest, if the police officer has a reasonable suspicion that the person is committing or has committed or is about to commit a crime and has reasonable belief that the person may be armed and presently dangerous. In fact, 2 Cleveland lawyers argued that historic case before the Supreme Court. They both were 1953 graduates of Cleveland Marshall Law School and members of our Hall of Fame. And you'll know at least one of them for sure. Louis Stokes, before he was elected to the US Congress, and Reuben Payne. Oh, and one more connection. The trial judge in Terry was Judge Bernard Friedman, who was the uncle of one of our panelists, Gordon Friedman. And that leads me to our panelists tonight. First is Gordon Friedman. He's a member of the Cleveland Community Police Commission. I had the privilege of also being a member of the commission for 4 years, and Gordon's and my service overlapped, and we worked closely on many issues. Gordon is an activist, criminal defense attorney, who has worked as a civil rights lawyer for over 40 years after starting out in the public defender's office. He was the founding director of the Cleveland Free Clinic, and a special note of pride, he's a member of our Hall of Fame, as Louis Stokes is, and the longest serving adjunct professor at Cleveland Marshall, where he's taught since 1976 and currently teaches criminal procedure. Next, and by the way, I'm doing these alphabetically, is Aisha Hardaway. Aisha is the deputy monitor of the Cleveland monitoring team. She is an associate professor of law at Case Western University School of Law. Professor Hardaway teaches as a clinician in the Milton Kramer Law Clinic, and Aisha is the co-director of Case Western Reserve University's Social Justice Institute. Our next panelist is James Hardiman. James is a noted civil rights attorney who has fought racial injustice as an attorney in private practice and many years ago as an assistant city prosecutor before becoming legal director of the American Civil Liberties Union of Ohio. He's a past president of the Cleveland branch of the NAACP. And yes, I have to admit a special note, pride again. He's a 1968 graduate of our law school and a member of our Hall of Fame as well. Next is Kerry Howard. Kerry is Cleveland's director of public safety. He's a former chief prosecutor for the city of Cleveland, a former assistant US attorney, and he served as a major in the United States Air Force Reserves. And when I tell you the next thing, you're going to probably think I picked all these panelists myself because yes, Kerry's a 2007 graduate of our law school, but I tell you, it's just coincidence, and he's undoubtedly a future member of our Hall of Fame. Chief Calvin Williams was unable to join us this evening, but we're pleased to have Cleveland Division of Police Sergeant Kenneth Ryan with us tonight. I don't know yet whether he's on the call, but if he's not, he'll be on soon. Sergeant Ryan helped develop the division's search and seizure curriculum, in which he functions as the lead instructor for the division. Prior to his current assignment, he served as the officer in charge of the police academy, where he managed and oversaw the training of hundreds of entry police officers of the division. And we have 2 individuals tonight who will be present on the call to provide clarifying comments and share critical points as needed. From the United States Attorney's Office, we have Assistant U.S. Attorney Michelle Heyer, and from the City of Cleveland, we have Assistant Prosecutor Thomas Fisher. And tonight, Alicia Ellis will present the community questions at about 7 o'clock. She is the founder and creator of the multimedia platform Mas Luray. She's also the co-founder of the women's empowerment group Fierce Women on Board. Okay, that's a mouthful. Now we're ready for the panels. Welcome everyone, and thank you for taking the time to lend your expertise and perspective to tonight's dialogue. I've asked each of our panelists to give a 2-minute opening statement about their perspective on how the Cleveland consent decree deals with the issue of search and seizure and how the Cleveland Police Department should deal with search and seizure issues. So we're going to start again in alphabetical order with Gordon Friedman. Gordon, it's all yours.
Thanks, Lee. As you should or do know from these series of forums, in 2014, the Justice Department became involved in incidents in the city of Cleveland involving deadly force cases, shootings by police officers, and made a determination that the city's police department and personnel had been violating the Constitution. And as a result of that, a consent decree came about in 2015 with the purpose of imposing standards upon the city of Cleveland Police Department to ensure constitutional violations were not being created and carried out by the city as it had in the past. And the consent decree, as it relates to changing the police practices and culture, is clearly not the final answer to unconstitutional policing in Cleveland. However, it does represent progress and reform as to the issues that it raises. And in particular, the consent decree as it relates to search and seizure in the Fourth Amendment Constitution is very clear about what is and is not unconstitutional conduct by law enforcement's interaction with citizens. And it clearly prohibits racial profiling, stopping people based on race or gender or their cultural background. It does away with and forbids searches based on neighborhoods, or as they say, high crime areas. And it also is clear about that a person cannot be stopped for a hunch rather than reasonable suspicion. As a member of the Cleveland Police Commission, I am the chairman of the Search and Seizure Work Group. And it is our position to examine the city's policies and to make recommendations to them, to give them input on how the city, through their policies and their general policy orders, can better serve and better communicate with the community. Our work group is made up of members of the NAACP, the ACLU, Quality Ohio, Black Shield, and the FOP, as well as 4 people with law degrees, etc. So we have met, we've analyzed the GPOs, citizens have attended our meetings. We're very concerned in terms of the rights of juveniles, particularly, as well as members of the LGBT community. A year or so back, probably a year and a half, the work group met with the city in an attempt to carry out a dialogue with the city. DOJ, Department of Justice was present, as well as others in the community. And we had a dialogue regarding what we thought our proposals for GPOs and changes as it relates to search and seizure.
Hey, Gordon, this is your 30-second warning.
Thanks. We thought it was a good, but I get 3 minutes, Lee. We thought
you're past your 3 minutes, Gordon.
I got 5 minutes. We thought that the meeting was a good meeting. Some of our recommendations were accepted. However, at a later retreat, unfortunately, the chief of police, Chief Williams, thought it was a waste of time, and DC O'Neill, his second in command, thought that we were bullying the city. I will stop there, but that reaction is reflection of the city's attitude of our input.
4 of the panelists tonight are lawyers. Asking lawyers to limit their comments to 2 minutes is a challenge, as you just saw. But we're going to try again with Aisha Hardaway. Thank you, Gordon.
Watch me follow directions really well, Dean Fisher. Thank you so much for the introduction. I am definitely feeling a bit outnumbered with all of the professors, with all of the lawyers from the school down the street. Thank you to the United Way and the NAACP for all that you do to make these community conversations a reality. In May of 2019, the monitoring team submitted a set of policies for the court's approval to ensure that stop, searches, and arrests made by officers within the Cleveland Division of Police comply with the Fourth Amendment and other constitutional requirements. The development of those 5 policies was the result of a strong collaborative process between the city, DOJ, the monitoring team, and a dynamic and well-informed work group. You just heard Gordon talk a little bit about this, convened by the CPC that included local law professors, practitioners, and other subject matter experts. That process also included extensive community engagement to both educate community members on the legal parameters of police encounters, voluntary contacts, detention, arrests, and warrantless searches. And it also was an opportunity for the city to receive input and feedback on those proposed drafts. Since that time, the monitoring team has engaged with the city and representatives from the Department of Justice on the development of search and seizure training curricula. The division is in the process of conducting or rolling out the second iteration of that court-approved training, and members of the monitoring team will observe and assess the delivery of it on an ongoing basis. How'd I do?
You did very well. I'm impressed. Okay, thank you, Aisha. Next, we're going to go to James Hardiman. And you should unmute yourself, James. He's about to unmute himself, everybody. Okay, there he goes. Good.
Can you hear me now?
We can hear you now.
I had started to say that I appreciate the very courteous and grandiose introduction. I wish I was worthy of it, but I'm just a humble servant, Lee. I was going to talk a little bit about how we got where we are and what the Fourth Amendment actually means, because in reality, they are just words. In practice and on the street, what does that mean to people? For a long time, we felt that the Fourth Amendment was important because in colonial days, the British had general warrants that didn't identify the place to be searched or the thing to be seized. As a result, with the passage of the Fourth Amendment, we were able to finally get exclusions of illegally obtained evidence in federal courts, but that had nothing to do with state courts. And as Lee indicated, there's a very famous case, Terry versus Ohio, but there's another famous case, Mapp versus Ohio. Some of you may remember or may know where Milverton is. Well, Dolly Mapp was a woman who was known to frequent boxing circles, and the police came by her house looking for somebody. And there are names such as Shonda Burns, such as Donald King. They may sound familiar, but the bottom line is, after that decision in 1961, illegally obtained evidence could be excluded in state courts. Prior to that, it was only excluded in federal courts. So how do we get where we are today? In many instances, police officers function under the assumption that the Fourth Amendment is nothing more than an obstacle that prevents them from doing their job. And I know a lot of well-minded people who take issue with that. They strongly believe that the Fourth Amendment is intended to keep police honest and make the streets safer for all people, whether they visit or work in the city or for whatever reason happen to be there. So back in 2012, and this is a little known fact, the NAACP was the first organization to write a letter to the Department of Justice and invite the Department of Justice to come in and investigate Cleveland's police department based on the fact that there were a number of instances of excessive force, illegal searches, And as a result of that, the city at a subsequent date also agreed to come in. The consent decree doesn't mention the NAACP or the ACLU, who were the first ones to request assistance from the Department of Justice, but the history books will note that they did feel that there was some reason to bring in the Department of Justice. As a result, there was a finding. After the finding, the city, kicking and screaming, signed on to a consent decree that, among other things, prohibited unreasonable searches and seizures and, quite seriously, racial profiling.
James, I'm going to ask you to hold your fire right there. You'll get a chance to continue. And we're going to go to our next panelist, Carrie Howard. Carrie?
Thank you, Dean Fisher. Yes, I'm proud to be from that school down the street, Cleveland Marshalls. Thank you for that. Also, thank you to United Way and the NAACP for these important conversations. The members of the Division of Police, this administration, myself, we are amongst those that take it very seriously, take the Fourth Amendment very seriously. And we affirm that by providing policies, training, and procedures to ensure that investigatory stops are done in a professional, fair, and respectful manner. Those three words are very important: professional, fair, and respectful. When our officers come into contact or interact with the citizens of the city of Cleveland, that those three words have to resonate, because that's the faith that we want the people to have when they think about the Division of Police. That's the faith. That's the way that citizens should feel about the justice system. Now, we know that historically, not just here, but around this country, that folks have not felt like the Fourth Amendment, that the Constitution, and that the laws applied equally to all citizens. And we've gone through a significant amount of transformation, still going through doing so. And the consent decree has provided an opportunity for us to engage in some self-reflection and to adjust a lot of these policies. From that, we have a bias-free policing policy. We have a youth policy. We have several policies related to search and seizure that it's important for the community to familiarize themselves with, as we do train our officers in doing the same. We all have an interest in securing and protecting constitutional rights, promoting compliance with the law and policies, and ensuring that there is accountability. Not just accountability for our officers, accountability also for citizens who commit crimes and risk the safety of our communities. We know that the better we train our officers, the more familiar with citizens are with the policies of the Division of Police and their constitutional rights, we can reduce confusion and increase transparency. Now, I'd be remiss if I didn't mention that, I've been on for more than a year, and I can tell you that I've sat in meetings and had conversations with Chief Williams, and Chief Williams is a proponent of equitable, fair, and constitutional policing. Anyone who tells you different is not telling you the truth. There may be some breakdown in how we get there. There may be some breakdown in discussion, but it has never been the position of anyone in this administration to circumvent the Constitution as we go about, as our officers go about policing and working to make the city safe.
Thank you, Carrie. And last but not least, Sergeant Kenneth Ryan.
Thank you, Mr. Fisher, and thank you to the NAACP and the United Way. Part of my current role is I develop, research, and implement search and seizure curriculum for the division. Our training always starts with the division mission statement and an overview of the Fourth Amendment. This sets the expectations to our officers on how and when to conduct searches and seizures. Officers are expected to conduct searches and stops in a manner that not only safety of officers, I'm going to keep going, safety of officers and the public, but also conforms to the Constitution of the United States. In training, we stress to our officers, every situation is different, but citizens should receive professional, respectful service, which focuses on consistency. Consistency on the current investigatory stop that they're on or traffic stop should be the same for the prior stop and the stop after that. We also discuss reporting requirements and data collection forms, the importance to clearly articulate factors. And we don't just teach search and seizure in our search and seizure training. We always combine component of bias-free interactions with youth into the training. So it's not just search and seizure training, but it's encompasses more than just that policy. Just in closing, we stress that we conduct searches and seizures fairly and respectfully, consistent with our commitment to procedural justice, community problem-oriented policing, and our community values.
Thank you, Sergeant Ryan. I think we all know that there's a healthy degree of skepticism in our community that something's actually going to be done that makes true police reform as a result of the consent decree. So my first question tonight goes to our first three speakers, Gordon Friedman, James Hardiman, and Aisha Hardaway. And I'm going to ask them, do you believe that the Cleveland Police Department is taking the search and seizure provisions of the consent decree seriously? And do you believe that they're doing the right thing and what they've done so far in terms of adjusting their policies and doing training? I'll begin with Gordon Friedman. I'm sorry, no, I'll take that back. We'll start with Aisha Hardaway, then we'll go to James Hardiman and then to Gordon Friedman. So Aisha, what's your view as the monitor? What's your role and what's your perspective on that?
Right, so as the monitor, as a member of the monitoring team, obviously we assess the progress of the division and its implementation. And the monitor puts out every 6 months a semi-annual report submitted to the court that speaks to every area of the consent decree, including what we're talking about today. If you look at, we're about to be at our 10th semi-annual report. If you look at each edition or version of the semi-annual reports, you will be able to see where the division's progress has been made in the area of search and seizure. Obviously, in a calendar year, we don't touch every area, but for the last since 2018, 2019, we have been consistently hitting on the area of search and seizure, and we have submitted to the court for its approval, the policies, as I mentioned to you. And so the monitoring team has been pleased with the progress there, and really look forward to working with the city on renewed and continued progress.
Thank you, Aisha. James, what's your perspective on how the Cleveland Police Department has done in terms of taking these issues of search and seizure seriously?
I think there are a couple of issues. The first issue is developing policy. The second issue is making sure this policy filters down to the officer on the street. I think the city is making progress in developing policy. However, I'm not convinced, based on what I saw and what I see, that the officer on the street is internalizing or inclined to internalize these policies. In many instances, I hear that police officers see this as another check the box situation. And maybe it's going to require the retirement of some of the old heads so that the new officers that come in will be steeped in constitutional policing, will understand what search and seizure really means, will understand what racial profiling actually means, because all the data, even today, years after the consent decree was signed, suggests that minorities are still disproportionately stopped. And that's not just a phenomenon that's unique to Cleveland, that's throughout the country, regardless of whether or not they're stopped in their automobiles, their homes are illegally searched. And we've got to get a handle on this issue. And it's going to require more than just a policy, though the policy is a step in the right direction.
Gordon, on the Cleveland Police Commission, you've been on the front lines. I remember that you actually have been the leader in the commission on certain seizure issues. What were the recommendations the commission made to the department and how have they responded? And you're on mute, by the way, Gordon. He's finding the unmute button. I'm doing the play-by-play here as we wait for Gordon Friedman to unmute. Gordon, are you unmuted? I think instead of unmuting, he disconnected. So we'll be seeing Gordon back soon. But now we're going to go back to Carrie and to Sergeant Ryan. You're well aware of the skepticism, fair or not fair. What is going to be different now and in the future as the community sees how the Cleveland Police Department deals with stop and frisk and search and seizure issues? And we'll go to Carrie first.
So what's going to be different is going to be it's not so much different as much as continuing. We're going to continue to advance this subject matter in training. Something that we've been adding is also accountability. Once citizens feel that they have been unconstitutionally or improperly subjected to a search or seize, we encourage them to call Office of Professional Standards so that we can become aware, so that we can hold officers accountable through discipline and through training, or a hybrid of both. That's very helpful because it changes the tone and the temperature of the environment with regard to what's tolerable and what's not, what's acceptable and what's not is a better way to say it. But really, it's going to be through our academy and through the curriculum that's being developed. And I'll let Sergeant Ryan touch on some of the training that was done in collaboration with the DOJ, the members of the consent decree, and the Cleveland Law Department.
So the Academy unit works closely with the city and county prosecutor's office in developing our search and seizure training. So that has really increased our knowledge base on constitutional law. Also, they co-teach the class with us. So not only is a Cleveland police officer teaching the class, it's co-taught with either the city or county prosecutor. One of the things I just wanted to touch on is data collection forms. So in July, we rolled out a data collection form. So every time an officer does any type of investigatory stop or traffic stop, they're required to fill out a data collection form. So one of the comments was maybe it's not making it all the way down to the officers. Well, now we have a mechanism to make sure that's occurring, because those data collection forms get sent to the supervisor, and the supervisor either approves or disapproves of the stop.
One of the things that I think people hear about all the time are searches of cars. Can the police search a car's trunk following a routine traffic stop? When can they pursue a car? And we obviously know of the famous case here in Cleveland where there were many, many police cars pursuing one car. So my question is, what recommendations are there to change those policies, and what's being done to change them? I'll ask first Carrie Howard to speak to that issue.
Dean, I would like Sergeant Ryan to speak to the training with regard to searches of automobiles and as a whole. Go ahead.
Okay, sure.
So the search of the automobiles, could you repeat your question just so I'm clear?
Yeah, it's a two-part question, Sergeant Ryan. Can the police search a car's trunk following a routine traffic stop? And what are the policies in terms of when you can actually pursue a car that's running away from the scene or driving away from the scene?
Okay, so the first part of your question is no. An officer cannot search a trunk just based on a routine traffic stop. So the answer to that is no. Our pursuit policy is pretty clear. Officers can pursue if there are certain violent felonies that were committed, or if the officer has reasonable suspicion to believe that the driver is intoxicated. So that is kind of our two-part breakdown. It's a very large policy that expands on those 2 points. There's a specific set of circumstances and criteria, but generally speaking, those are the two factors.
Okay, Gordon, I see we're back to you. If you can unmute yourself, we'd like to get back. And once you unmute yourself, Gordon, I'm going to advise you stay unmuted for the rest of the evening. There he is. Okay, we've got Gordon. You just unmuted yourself and muted yourself back. We know Gordon Friedman will not be a Zoom instructor anytime soon. There he is. Okay, Gordon, all right. Your thoughts.
My thoughts are that I have to echo, after a long pause, Jim Hardiman's comments regarding, I believe the city and the CPD have made progress on policy, some of which were recommendations that our work group recommended to them. But as he said, policy and practice are two different things. And one thing that I don't think the consent decree can do immediately, but in the future, is to change the culture of the police. And in particular, the new police officers coming in and getting training will benefit from some of the changes that have been made. One of the recommendations that our work group made to the city, which was rejected, is that we offered ourselves 3 law professors, actually in the public defender, to participate in training with the police. We believe that the police should be trained by lawyers and on areas that they are expert on. And that has been rejected by the city, at least at this point.
Carrie, why can't lawyers do the training in conjunction with the police? I think Sergeant Ryan obviously is extremely well qualified to do the training. So why not have co-instructors?
So they do training with lawyers. I'll touch on a point is that early on, and I was still chief prosecutor at the time, is that I had a discussion with Professor Luke Katz, who was on the CPC, about this. I did reach out to him several times by phone call and email, and I had never received any return communication. But we do have members from the city prosecutor's office and from the county prosecutor's office who collaborate on this training, observe the training, and give officers real-time feedback there as they go through scenarios and in the classroom setting. So we do have attorneys there. Members of the DOJ has observed the exercising of this training and the participation of the prosecutors. Last year, because of COVID, the training stopped, but it's restarting this year, and the county prosecutor's office is participating this year. So we do have attorneys involved with the training of search and seizure.
But those attorneys are all prosecutors. And it seems to me that you need a different view for the benefit of the police themselves.
I'm not going to disagree with you, but that was the whole point of me when I sent emails and phone calls and they weren't returned. Perhaps I can get your information and reach out to you. And
well, you're a former student of mine. You can call me anytime.
And I'm well trained.
You are that.
The nice thing about these conversations, we actually get some things done and we improve communication. So I'm glad to see that. Okay, I'm going to give you a hypothetical. It's really not a hypothetical.
Dean Fisher, can I interject one thing?
Of course, go ahead. And please introduce yourself before you say anything.
Absolutely. And you did introduce me real briefly to start. I'm an assistant prosecutor with the city of Cleveland. My name is Tom Fisher.
No relation to me, right?
No relation to you, Dean,
okay.
No, but I am a graduate of your institution as well.
Of course, of course.
But I just want to point out, I was one of the 3 city prosecutors that rotated in and out of the in-service training for the police for, among other things, their search and seizure training. And so I can be another person to attest to the fact that both the city and county prosecutors' offices are involved in not only the development of the curriculum, but the training itself. And although I would echo Director Howard's concurrence with Attorney Friedman that it could be beneficial to have defense attorneys or academics involved on a firsthand basis as well, I think it's important to remember that as prosecutors, we have many of the same intentions for the training that defense attorneys would. In addition to the fact that just as all people, or attorneys in particular, would believe that the protection of constitutional rights of city residents is important. Additionally, we have a very strong interest in making sure that police are collecting evidence appropriately and preserving evidence appropriately. Because if it's not done so, our win-loss record in courts is going to go down, and we don't like that. We want to successfully prosecute cases both in municipal and common police courts, and evidence that's not correct or collected appropriately or constitutionally is going to make that more difficult. So we absolutely do also have, again, many of the same intentions for the training as any other attorneys would if they're attending as well.
I'm going to ask our other 3 panelists if they want to react to anything that Thomas just said or that Carrie just said. James or Aisha or Gordon. James, go ahead.
I've got a serious concern with any prosecutor's office. I'm not just picking on Cleveland, that is looking at a one-loss record. I always thought that the purpose of the prosecutor, be it city, state, or federal, was to do justice, not to get convictions. And if that is in fact the objective, then it would seem that people that are on the front lines, including defense attorneys, would be able to bring a fresh perspective to the issue of search and seizure. Prosecutors oftentimes are teaching police officers how to make sure they can cut corners and make sure the evidence they collect is admissible. Defense attorneys, on the other hand, will either get a crack at them in the training process or when they're on the witness stand responding to a motion to suppress. And it would seem to me that defense attorneys should be involved at the outset, not after the fact.
Aisha, anything you want to comment on that?
With my monitoring hat? No, sir. Thank you.
That's fair. Okay, you have certain limits on your role. I understand that. Okay, I'm going to give all of you a hypothetical, but it's really not much of a hypothetical. Going back to that Terry case in 1968. Let's assume for a moment that there are 3 African-American men on Euclid Avenue peering into a window in the evening into a store. There's no reports of any crime in the area. A policeman goes by. He's curious about what's happening. What can the police do in that situation, or should they do anything? I'm going to ask first Sergeant Ryan and Carrie Howard to answer that question. Sergeant Ryan, if that hypothetical is posed to you in training, what do you tell your police officers to do?
So the first thing I'm going to want to do is I want to get as much information as I can. Is there a law enforcement purpose? Is that the reason the police are in the area? Maybe there were special attentions. Maybe there was break-ins in the area, something like that. So that's the first thing I want to do. I want to also know what observations do the officers see? Do they believe they have any reasonable suspicion? And if they have that reasonable suspicion, I want them to be able to clearly articulate that to me. So one thing I do in training, and I don't mean to dance around your answer, is when hypotheticals are posed like that to me, I say, give me more information. Give me more information. Because right now, with what you're discussing, you wouldn't be able to stop those individuals.
Because there would be no basis of suspicion. And if you did stop it, it would be racial profiling and most likely.
So for that information, tell me more. Are there recent break-ins in the area?
Right.
The break-ins occur at night. Is it multiple people committing these break-ins? All those are going to build reasonable suspicion as to why a police officer may stop those individuals.
Okay, Carrie, anything you want to add to that?
So I would echo what Sergeant Ryan just said, and I would add that, you know, if there's a real problem, if you can't articulate why you engaged, why the officers engaged, there's a real problem. And if they can't, then it doesn't need to stop there. We need to investigate and find out what happened so that it doesn't happen again and correct that action. I'm a career prosecutor myself, and prosecutors absolutely should be justice seeking. And that means, if the evidence isn't there, dismiss the case. If the evidence wasn't obtained constitutionally, it doesn't get in. You only have one reputation and you can lose it very easily. And you have to be critical of the officers who are bringing charges to the prosecutor's office for charges. And you have to query them and dig in why those charges are justified. So in that type of situation, I would want the officers to thoroughly explain their actions.
Okay, James or Gordon, do you have any perspective on that hypothetical?
Lee, in your hypothetical, assuming this is on Euclid Avenue at East 12th Street, and assuming the police officers see nothing more than 3 African Americans, they have absolutely no basis to stop them. Now, they can continue to watch, which was the case in Terry. They can continue to investigate. There's nothing wrong with that. But when they take it a step further, then they are crossing constitutional bounds, and they are getting into an area about which they are justifiably complained about. They're racially profiling some people. I've had conversations with some consul people, who I will not name, but they took the position that if they see 3 or more, and these were Black consul people, if they see 3 or more African Americans, they instruct the police officers to take them down, because the streets have to be safe for the community people. And they were criticized for this, but they stood by their guns. We have to make the streets safe. Well, that is the basis as to why many people are suspicious about the police. That's the basis for a lot of litigation under 1983 against the police. And that's why racial profiling is such an insidious offense to the Black community.
1983.
And I would add to that, that the standard of reasonable suspicion plays into racial profiling and plays into hunches and not probable cause. Terry was a bad decision regardless of who wrote it. It gives the police too much leeway in their contact with citizens. And besides that, reasonable suspicion only allows them to pat people down. It doesn't allow them to stop and make inquiry.
Aisha, let me ask you a question in your role as the monitor, whether or not the monitoring team is looking at best practices around the country in the area of search and seizure and then comparing it to what is happening in Cleveland. Is that part of the role of the monitor? And are you doing that, you and your colleagues, that is?
Yes, absolutely. As a part of the technical assistance that the monitoring team has been providing to the city, thinking about the best practices in the development of policies. As I heard the banter back and forth, it brought to mind something that the division established early on, and that was an adherence to the concept of procedural justice. Just because you can do it doesn't necessarily mean that you should do it. And wherever there's wiggle room as it relates to reasonable, being able to articulate reasonable suspicion and how that can erode legitimacy for policing, that's something that the division early on said that they recognized and were willing to put into a general police order. And so that was the first thing that came to mind as it relates to the development of policy. As it relates to training, the monitoring team absolutely has it. Well, if anybody has been reading our semi-annual reports every 6 months, folks are likely not surprised to know that the monitoring team is eager for the training department within the city police department to gain additional capacity in its ability to deliver dynamic best practices training that comports with the needs of adult learners. That's something that we've been saying for some time, and I'm encouraged by some of the progress that's been made in the training area by the division. But and we still have more to do.
I want to remind our viewers that in a few minutes, you'll be able to ask your questions. And I want to give you that number again, where you can text your questions. That you can text your questions to 216-307-5632. It's on your screen right now. 216-307-5632. Let's do it one more time because we want to hear from you. You're tired of hearing my questions. We'd rather hear your questions. 216-307-5632. Okay. I'm going to ask each of you to put your crystal ball on. We're 2 years from today. What do you hope and expect to see differently with regard to how the Cleveland Police Department deals with issues involving search and seizure? And I'm going to ask first Gordon Friedman to answer that question.
2 years from today, Lee, I would hope that training of the police department, CPD, on search and seizure is an integrated practice of both defense lawyers and prosecutors. I would also hope that the culture of the Cleveland Police Department has changed as a result of advances made by the consent decree. The language in the consent decree regarding searches and seizures is very clear and explicit, and the policy is fine. The practice is open to debate.
James?
I think the consent decree has great aspirations. And if we are able to realize those aspirations, we will have made substantial progress. I'm concerned, however, that as we check off boxes, we are simply figuring a way to get out from under the federal court and the consent decree. And until we can incorporate those goals that are contained in the consent decree into practice, particularly among new officers, I think we've still got a way to go. And I'm not too optimistic that we can do that in the next 2 years. I would hope, but I would not be optimistic about it.
Well, Aisha, from the monitor's perspective, what is the monitor team's goals a year and 2 years from now? Where do you think we should be at least 1 or 2 years from today?
Oh, I thought you said 5 years, Lee. I love the question if it was 5 years.
Well, you can answer 1, 2, 3, 4, and 5 if you'd like, whatever you want to do.
You know, obviously, one of the things that I mentioned earlier was it would be wonderful in the area of search and seizure for us to see the development of dynamic and engaging training from the training division on this area, but also every area of the consent decree, so that officers are equipped with what they need, that they feel more than prepared to meet the needs of our community, and also to obviously comply with not just the requirements of the consent decree, but most importantly, the requirements of the Constitution. I also hope and understand that others, I understand, and I hope that others understand that any healthy organization is going to have to adjust and adapt as time goes on, and that these are evolving standards. And so the consent decree as it was written in 2015 is just one snapshot of what was the best push at that time in the agreement that was made by the parties. If I'm putting on a crystal ball and thinking about life in Cleveland, you know, beyond 2 years, say 5 years from now, when there isn't a consent decree, as a community member, it is certainly my hope that our police department and the community that it serves has a healthy relationship that allows for there to be collaboration and input to meet the needs of those evolving standards in a way that mirrors some of what we saw in that work group session that I mentioned in my opening statement.
Carrie and Sergeant Ryan, what are the city's goals going forward, and where do you believe we'll be 1 year from now and 2 years from now on these issues of search and seizure? Carrie?
So I think that, you know, our goal is to strive to have a reputable and revered division with equally revered training and policies, as well as data collection. It takes work, and it's not something that we can rest on our laurels on. We have to continue to strive to improve, and no matter how good we get, whether it's in 2 years or longer than that, is that we're always continuing to strive to do better. If we take that path and we always are evaluating our policy and working to continue to change the culture and be a model for that change of policing, so that we can be looked at from departments around the country to look here to see what we're doing, we can gain the trust of the community and continue to foster that trust. So that's where I would like to see us. Sorry.
So I'm very optimistic about the future of our search and seizure training. With the information that we're able to gather, it's going to assist the training section in continuing to build curriculum. So these stop data collection forms, we're going to get information about who, what, where, and why individuals were stopped. So we can now tailor training to any issues that we see. Those coupled with body-worn cameras, they're going to be able to really give us a feet on the ground understanding of, is our training effective, what changes need to be made, and what training we're going to do going forward.
Sergeant Ryan, we know that there are a number of police who feel that they're being victimized and that they're being unfairly accused, and that as a result, there's some resistance, not just in the Cleveland Police Department, but in police departments around the country to these kinds of changes in policies. To what extent are you experiencing it? And more importantly, how do you deal with it?
So anytime that there's a drastic change, it's human nature, people are going to be afraid of it, right? One thing I will say about body-worn cameras, when body-worn cameras were first rolled out, I believe in 2016, there was some trepidation with body-worn cameras. Talking to officers that come through training now, and including myself, you're not going to find an officer that wants to go out on the road without a body-worn camera. Because the body worn camera is going to be able to paint the entire a large picture on what occurred. So I think that body worn cameras plays a big role in officers understanding if a complaint was made and why, or maybe the complaint was unfounded. But now we have a mechanism to see that.
Okay. We're now at about 7 o'clock, and so I need some guidance from our hosts and Alicia as to where we go next. Alicia, what's the next step? Alicia, are you there? Go
Yes,
ahead.
we have
Go
some
ahead.
great community questions here. So thank you for the opportunity to partner with community and asking these questions to the panelists. Our first question so far, and we also encourage folks to continue to text in. If a citizen is stopped by the police driving a vehicle and the police ask if they can search the vehicle in an intimidating voice, and the citizen says, yes, but won't want to get out because of fear, and the officer finds contraband, is that a legal search?
I would say no.
And why is that?
It's not legal. It's a pretextual stop and search. I don't blame the person for not wanting to get out. And if the officer says, can we search your car? The answer should be no.
Carrie Howard, Sergeant Ryan, do you agree with that?
I just wanted to jump in. The first thing is, in that situation, I wouldn't want that officer to search my car either. One of the things we teach is if you do ask for consent for whatever reason, to not physically coerce, mentally threaten, or intimidate that individual. And if that individual in the car feels like they were coerced or intimidated, then that would not be a valid search.
And one thing that the consent decree does provide for on consent searches is that the officer is obligated to tell the individual that they do not have to consent to the search. And that's a shining light on the consent decree regarding searches and seizures. So they can decline, and that's not a basis for an arrest.
Yes, and what two things to touch on that, we actually have a consent form that individuals can fill out. The officer can explain why they're asking and where they're going to look, and the individual will sign it. And one of the things we teach that we stress in training is individuals can have the right to revoke consent at any time. So if somebody were to search a car and an individual says, I changed my mind, I don't want you in there, that officers are obligated to remove themselves from that situation.
Let me ask a follow-up question before we go back to Alicia. Let's stay with the same hypothetical. Let's assume that the driver, because they're afraid, because they feel that they're about to be unfairly accused, drives off. That's not cooperating with the police, and you are in pursuit. What are the rules that you operate under in which, whether you can pursue that car, how fast you can go, and whether there's at some point you must stop?
I think so. So the duty to apprehend the offender is never going to outshine the due regard that the officer has for the general public. So is that person a danger to the public if they remain at large? These are decisions that the officers have to make in real time. The first part of your question was what again? Oh, if they can pursue the vehicle.
Yes.
So if the officer does not have probable cause or reasonable suspicion that violent felony had occurred, or that the driver is intoxicated, then they are not authorized to initiate that pursuit.
There is a case law in which police officers are observing some individuals who happen to be Black, and they take off running. And the question arose as to whether or not the police could pursue them if the police did not actually observe the commission of any crime. And the court seemed to suggest that yes, they can pursue them because people that are innocent don't run from police. That was, in my opinion, a terrible decision, but that's what the court said.
And I understand that, sir, but what we teach is fleeing from a police officer in and of itself is not reasonable suspicion to justify a foot pursuit. And that's
good.
And that is also the position that the city prosecutor's office has taken on actual cases in court. And in cases that, in particular, one that I had in the county that just, running is not a crime. So I echo what Sergeant Ryan says.
Of course, I think it's fair to say it's never a good idea to run, but it's interesting to know that you have a policy that you're focusing on the public's safety in those situations. This is a reminder to everybody, you can text your questions to 216-307-5632. Let's go back to Alicia.
Awesome. What training courses are provided to police to reduce vehicle pursuits? And are vehicle pursuits found to be more frequent in Black and Brown communities? If so, what is being done to fix this issue? So two-part question here.
Carrie and Sergeant Ryan.
Sorry, can you repeat the question? I only got a part of it.
Here, go ahead.
Yes, the question is, what training courses are provided to police to reduce vehicle pursuits, and are vehicle pursuits found to be more frequent in Brown and Black communities? If so, what is being done to fix the issues?
So there's training on the pursuit policy that we have. I know we had a discussion about the pursuit policy some time ago, and that training, that policy, as Sergeant Ryan can elaborate on, delineates the criteria in which a pursuit can happen, and that the officers on the ground can call off a pursuit based off of the totality of the circumstances that they experience without concern for discipline. Now, we have seen pursuits in the city, really pursuits coming from outside of the city into the city, on both sides, on east side, west side, going north near the lake and south of the lake as well. But they happen throughout the city.
And I'll touch on 2 points. So police officers, when they come into the academy, they're mandated 40 hours of emergency driving by the state. We also provide an additional 40 hours. So Cleveland police officers coming in get anywhere between 64 and 80 hours of emergency driving. The second part of your question, we also train our officers on the pursuit policy. The second part of your question is do those pursuits happen in Brown or Black neighborhoods? We don't have stats to be able to determine that, but we're hoping with the data collection forms, if we see something like that, then we can tailor our training and try to figure out why.
And just to add to that would be folded into our bias-free police training as well.
If any of our panelists always want to jump in and add anything else, you don't have to wait for me to even ask you. So Aisha, James, Gordon, if there's anything you want to add to that before we go to the next question from Alicia? Let's go to Alicia then.
Is the monitoring team just checking boxes, or are they assuring that the CDP conform to the precepts of this consent decree?
That's for you, Aisha.
And I think that's a great question that community deserves an answer to. So I'm happy to take a stab at it. I will speak for myself if that's appropriate. I think that's most appropriate. The work that I engage in conducting audits and evaluating the policies or the training curriculum, I take that very seriously. And my goal is to be completely transparent with the department or with the division as it relates to my feedback on that. And Director Howard and Sergeant Ryan know me as a part of that work. And so my goal really is to be very forward and direct in my assessment with the hopes that the city will rise to the occasion. And I've seen that happen, as I mentioned earlier, in a few instances around this topic of search and seizure.
Lee, can I add to that? Do you mind?
Please go ahead.
So, yes, the consent decree evaluates the city on criteria, right? And I have voiced this, and I've had these conversations with Professor Hardaway as well, is that if we take a subject matter and we work just to do right and we work to do good, we can and just create an overall better division of police. Those boxes will be checked just by that correction. So it's a dual process. I think it's a process of satisfying the consent decree, but also going beyond that and just doing what's right, implementing correct policies, correct trainings, creating a correct culture, and just by doing that as well, satisfying the consent decree.
Can I ask a question, Lee?
Please, Gordon, go
ahead. Carrie, how do you change the culture of the police?
I hear this from other officers, right? is that the environment is different. There's things that may have been done in the past that you need to second think because there's a different way that we handle discipline than we have in the past. I think that has contributed to changing the culture. I think that the body cameras have assisted in changing the culture. As Sergeant Ryan stated, officers don't want to go out and leave without their body cameras. Those body cameras have exonerated officers of false allegations or even mistaken allegations by allowing us to see what happened in real time. The scenario with the traffic stop that was given, that if an officer says that asked to search the car, does it in an authoritative way, in that kind of situation, the body cam would be invaluable there. So I think that the culture is changing through equipment, training, and accountability.
Is it necessary for the police, the Cleveland police anyhow, to follow a military structure?
What do you mean? Do you mean rank structure or organizational structure? What do you?
Both, correct.
Well, so Professor Gordon, I'm in the military, Marine Corps, Air Force.
I know that.
Right? You have to have good order and discipline. It's a must. Without good order and discipline, you erode accountability. Everyone has a boss. Every officer in uniform that carries the same.
Doesn't that, however, translate out to the street where the community members find police officers in uniform and act carrying on in a military fashion?
Now you're talking about two different things. You're talking about military structure, right? Which I think aids, because if a citizen is encountering a patrol officer and says, "Call your sergeant," that sergeant is going to come in again. That's military rank. That's that rank structure that the citizen is relying on to come and correct perhaps a patrol officer who's doing something that they should or need to be advised by a supervisor. Now, if you're talking about a military operation, and that's what I think that you're getting to, I think that we have the division of police. Police's civilian communities, in comparison to the military, they're civilians themselves. But these are uniformed men and women who are in service of the citizens of Cleveland. So I think that, yes, the rank structure, the organizational structure, yes, it's important to have that good order and discipline, but to be a paramilitary force in the community, no, I don't subscribe to that. I don't think that anyone in the division would believe so as well, unless they're different.
Thanks.
Alicia, back to you.
Yes, our next question here is a little bit of a statement and an observation. I'm troubled by the prosecutor's response that the search and seizure must be respected in order to collect proper evidence for convictions. How do you ensure the public rights are respected if motives are based on getting a high rate of convictions?
I think that goes back.
That was probably a flippant or mischaracterization. I didn't choose my words carefully, I guess, put it that way. So at the first part of my statement, I thought I was very clear, but perhaps I wasn't, that the prosecutor's office, the first thing I mentioned was we have a similar intention to any attorneys, especially defense attorneys, that we want constitutional rights protected. Okay. Now, the second part, what I was really trying to get at was, I don't want bad evidence under any circumstances. So if it comes into our office where, a police officer wants a charge against an individual and there's bad evidence, that case is not going to get charged. So I don't want officers getting it in the first place, and I don't want any cases charged based off of that. So again, the prosecutor's office its first goal is the protection of constitutional rights. And the second goal is, in our training, we explain there's proper ways to do things. And it's, I understand Attorney Hardiman, I think it was, who stated that he might view just the prosecutor's office as wanting to teach officers shortcuts and stuff like that. And I understand his concern, absolutely. And that's why I also stated the prosecutor's office, both county and I can only speak for the city, but I'm sure the county as well, would be more than happy to have defense attorneys at the in-service training. What the point I was trying to make, and again, I apologize for not explaining it well enough, I suppose, or appropriately, I suppose, is that we do not want bad evidence. We don't charge cases with bad evidence. So the constitutional rights, we want officers to understand their citizens' rights and officers' responsibilities first and foremost. But we do want justice, and that means justice for victims in many cases. And therefore, we want appropriately obtained, constitutionally appropriately obtained evidence to try to get justice for those victims.
Any other panelists have something to say on that issue? If
I
not,
appreciate the clarity.
thank you, James. Let's go back to Alicia.
Yes, Lee, this is our last question here from community. As a woman, I have always been taught that if I'm being pulled over, I have the right to keep driving until I get to a well-lit area. Am I allowed to do that? And how does the police officer know my intent versus assuming I am fleeing the scene?
So one thing, Sergeant Ryan here, that I'll jump in is it's always going to be based on the totality of circumstance, right? So if you're trying to get to a well-lit area, I don't know a police officer personally that would have any, we also would like a well-lit area as well. But it's based on totality of circumstance. Is the gas station a mile away and you're doing 65 miles an hour trying to get there? Or is it 2 blocks away? It's a much more well-lit area. So we want to get to that so that the individual is safe and the officer is safe. So what I would say if my loved one asked me that question is I would say, make a determination of, hey, how far is it? Is it reasonable? And then make sure you're in a well-lit area.
If I can add to that too, I've given my daughter this advice, is that if an officer gets behind you and you don't feel that you are in a safe area, call 911 to speak to a dispatcher to let them know what's going on, so that they can get that communication to the officer who was behind you and tell them that you're looking for a safe area to stop. I think that communication would be very helpful, and it kind of goes to the point that Professor Friedman had asked, right? This is that militarization, getting away from military and getting more towards that customer service oriented type policing, right? And that's what has to come across, that the culture of policing is changing, not just within the departments of police across the country, but the culture has to change in the community as well, to understand that they have avenues when dealing with folks who are basically have taken a job to help. I hope that was clear.
Alicia, any other questions you've got?
Yeah, we just had a couple come in here. So the city said that they have a form for the officers to fill out that started in July. Has the city submitted the data for July at this point?
That's a negative. I'm going to be honest, I'm not really in the data collection process. It's handled by another unit. We would receive, it's going to be analyzed, and then the training section would receive that data and base our curriculum around that data. But receiving it from the city or those types of questions, I'm sorry, I just can't speak to it.
But what we will do is we'll look into that question and get an answer back to the appropriate person.
I have a question I'd like to ask, and that is, underlying this entire discussion are a host of tragic shootings, primarily of African-American, and primarily African-American men. Many of these situations have involved minor legal infractions, where perhaps there's a taillight out, or they're passing a counterfeit bill in the case of George Floyd. Many Americans think that given all the violent crime that is occurring in America, and it is on a rise, why would police be spending even a moment of time on a broken taillight or a counterfeit bill and not dealing with violent crime instead? It's a question I'm asked all the time, so I have to ask it, Carrie, to you and Sergeant Ryan.
Thank you. Okay, there we go. So there are folks in uniform who are police officers that shouldn't be. I think that's a fair assessment. I don't think that anyone on this call would disagree with that. Anyone on virtual meeting. We have to do a better job at training officers, but you cannot let quality of life crimes go by the wayside. You have to address both of them. They go hand in hand. Traffic stops, it's proven that traffic stops result in felony arrests of violent criminals. You have to conduct traffic stops. The manner in which the officers interact with the public, it has to change, right? We know that policing historically has a problematic root, and we have to change the rest of it going forward. That means changing the way that we hire and being more selective of who we hire as officers, providing them proper onboarding and training, reinforcing that training, and also weeding out and getting out officers who should not be officers, who possibly should have never been hired. That's very candid.
Kerry, how do you do that? How do you weed them out?
Say it again.
How do you weed out those officers that should never have been on the police department?
Especially if they've already been hired and the union is going to come to their defense regardless of what they are accused of doing.
So what you have to do is you have to hold them accountable, right? This is where the body cameras come in. This is where the Office of Professional Standards, the Civilian Police Review Board, you have to hold them accountable. You also have to make sure that the environment and the culture is changing that makes them uncomfortable it's not the division of police perhaps that they signed up for. And you can't let them continue on in the uniform causing harm. Now, this is something that's very critical. You have to have citizen input, right? If something is happening, you have to have avenues, and we do have avenues for citizens to call and to file complaints. Those complaints are investigated by the Office of Professional Standards, reviewed by the Civilian Police Review Board, and referred for charges, administrative charges, to either the chief of police or to myself or to the safety director level. You have to do that. And we've seen that. I think that many of the officers who were here at the time that the consent decree began are no longer with the division. We have a lot of people who are new police officers who have come on in the last few years that this is all they know. All they know is being a police officer under the consent decree. And it's working here.
Kerry, would you allow for a police officer to be hired by the city of Cleveland who had been dismissed by another police department?
So the answer to that can be simple, no.
Good.
Right? But due process also requires as to why, right? We have to look at it. We have sat, I think, 3 classes since I've been on, and I haven't sat in office. I can say that we've had officers who have applied, who have been let go from other police agencies, not just municipalities, right? Cleveland Clinic, RTA, other, CMHA, other law enforcement agencies for smaller, more succinct communities. But my answer would be no.
As we near the end of tonight, Alicia, I would like to be able to give each of our panelists the opportunity to give a closing remarks on any subject they want that's related to the Cleveland consent decree. Obviously, we hope it's related to search and seizure, but I'm going to give them even a little bit more latitude than that. And Aisha Hardaway, because you've been outnumbered tonight by Cleveland Marshall graduates, it's only fair to give you as much time as you want. We're going to start with you. Your closing remarks.
Well, and what's funny is that I really don't have any other than, that the monitoring team looks forward to continuing to work with the city, the Department of Justice, and the CPC in the implementation and constant sort of reimagining, if you will, of the policies and the training that's necessary to ensure that the officers employed by the division are equipped to do what they need to do in the interest of their safety and the safety of everyone in our community. So that's pretty much.
Okay, thank you. James Hardiman, I give you some closing remarks.
I believe that the 3 gentlemen representing the city have the best of intentions, and I have the utmost respect for each and every one of them. But my concern is oftentimes with the police on the street. the ones that are trying to skirt the clear intent of the Fourth Amendment. In that regard, I want to quote Justice Brandeis, who was around even before I was born, and you know that's a long time ago. If the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself. It invites anarchy. To declare that in the administration of the criminal law, the end justifies the means. To declare that the government may commit crimes in order to secure the conviction of a private criminal would bring terrible retribution. That was a dissent, and unfortunately, years afterwards, we still are wrestling with the mentality among some law enforcement officials that the end justifies the means. It never does.
Thank you, James. Gordon?
Yeah, it's kind of hard to follow Justice Brandeis, but from a perspective of the Cleveland Police Commission, let me make two observations. One is that the CPC is going to have its second annual satisfaction survey and looks for community input on whether or not things have changed under the consent decree, and that is the community. And if you can plug into that, the CPC website, which is clecpc.org. Secondly, there is presently a charter commission pending that the voters will have an opportunity to vote for. And the purpose of that charter amendment is to make police oversight a reality and to make the Cleveland Police Commission permanent, not to expire with a consent decree, and to create a permanent civilian police review board. It is my belief that that will enable the police to follow through on the consent decree and its aspirations. And I also agree with Jim. The three city representatives have done a fine job, and I think their total intent is earnest, but practice is the most important piece of the puzzle, and it still is a puzzle.
Thank you, Gordon. Let's go to Sergeant Ryan next.
So speaking from a training perspective, the training section is prepared to use whatever tool is necessary to give the officers on the road all the information to interact with citizens. So we analyze body cams, our data collection forms, surveys. We build our curriculum, which is vetted by the prosecutor's office. And these are still foundational layers. We've only been through 2 iterations of search and seizure. Going forward, we have the county, possibly some defense attorneys as well. We're going to continue to build this machine to produce curriculum that's going to give the citizens the best interactions with the Cleveland police officers.
And by the way, as the moderator, I know I'm not supposed to make a biased statement, but I hope you'll consider adding a criminal defense attorney. I think different perspectives is always better than too few. And let's go to Kerry Howard for final thoughts.
So there's just a couple things I'd like to touch on is that I think that everyone has to remember that police officers, like those who enlist in the military, are a microcosm of society as a whole. And what that means is that you have all types of people who have biases and prejudices and they bring a lot of baggage with them who want to be police officers. We have put in place procedures to help filter that out, right? We have background checks, successful background checks that look at people's, any criminal history as well as their social media, boots on the ground, talking to neighbors and the people who know the applicant directly. Behavioral-based interviews so that we can check people at the door of their biases, prejudices, open-mindedness, and ability to follow instructions. Cultural competency training that we have within the division, and we're looking to broaden that as well to bring a cultural competency professional in to address and raise awareness amongst members of the Division of Police. The city of Cleveland is a diverse city, and it requires diverse officers. So we focus on that diversity and life experience also in recruitment as well. What's something that's desperately needed is we need people who live in the city to apply to be police officers in the communities where they live so that we can select officers for the Division of Police. The other thing is that I think that, and I said this last time I was on United Way calls, I urge citizens to read the Charter Amendment and find that it is much more than what is being presented. I'll say this personally, it's a bit nefarious, a bit self-serving. It's not all bad, but many sections of it is. Many sections is not just unconstitutional, I believe, but illegal. I think that we have to do a better job of telling the story about the successes of the Division of Police to its citizens and to neighboring divisions of police. And we have to do a better job of educating the community of how to exercise their voice with their councilman, their mayor, and their vote.
Before I turn it back to Helen Forbes Fields for closing remarks, I want to say thank you for giving me the opportunity to moderate tonight's outstanding panel of Carrie Howard, Sergeant Ryan, Gordon Friedman, James Hardiman, and Aisha Hardaway. It's been a privilege, and I throw it back now to Helen Forbes Fields of United Way.
And we certainly want to thank you, Lee, for moderating this evening's discussion. It's been a very lively and robust discussion, and it has a lot to do with the fact that you were our moderator this evening. So thank you. And thank you to all of our sponsors, Cuyahoga Community College and Rockwell Automation, as well as our many community partners for their support in bringing this important conversation to life. We also want to thank the Cleveland City Club, WOVU 95.9 FM, WOIO Cleveland, 19 News, and WKYC Studios, who live streamed tonight's conversation. Ideal Stream will also air a replay of the conversation next week on the Sound of Ideas. Lastly, we thank each one of our panel participants and community members for joining us on our mission to create a voice to encourage engagement, as well as advance understanding of the Cleveland Consent Decree and of one another. Our next panel discussion will be held on September 8th, and it will focus on the Cleveland Police Commission and citizen involvement, where the consent decree mandates that the City of Cleveland Division of Police will create formal and informal mechanisms that facilitate ongoing communication between the Cleveland Division of Police and the many Cleveland communities it serves. The Community Police Commission is composed of 13 members that represent the many and diverse communities within Cleveland. They also make recommendations to the Chief of Police and the City of Cleveland on policies and practices related to community and problem-oriented policing, bias-free policing, and police transparency. No doubt another robust discussion we have in store in September. So please join us by registering through our website at unitedwaycleveland.org. Registration is complimentary and open to all. So thank you once again, everyone, for joining us, and please have a wonderful evening. Good night.
All right.
All right.
Right.
What's new, just issued from the Weather Service, they're going to extend the severe thunderstorm watch out for the remainder of our counties. That will go through this evening. Areas in orange, that's where you have current severe thunderstorm warnings. That means the severe thunderstorm is imminent. This is what's staring us down. We've got a line of damaging wind producing thunderstorms that continues to race east. This formed near Chicago this morning. It's raced across Indiana. Lots of power outages in western Ohio. Timing this out, another 20 minutes or so for downtown, another 30 minutes or so for Menor. You see as that continues to push east. Heavy rain, lots of lightning. You can expect a shelf cloud with this as it moves in, heading into Lorain County, down towards southern Lorain County, Ashland County, then eventually down towards areas near Mansfield. The wind with this, we've got some strong winds offshore, 40, 50, 60 mile per hour winds, not out of the question with this. We'll continue to track this. Meteorologist Matt Standers was with me as well. We'll keep you updated throughout the show. Laura?
All right, Matt, thanks so much. Now we want to get to the latest on the COVID pandemic. We are going in the wrong direction. In fact, today, the state released its COVID numbers and 3,393 cases were reported overnight. For perspective, the last time we had 3,000 daily cases was back in February. Hospitalizations are also up with 147 patients admitted just in the last 24 hours. COVID patients, we're told, are occupying just over 4% of the hospital beds in the state.
Our senior health correspondent, Monica Robbins, joins us now. Monica, good afternoon to you. You look at those numbers and you watch the growth. It's disturbing, and I'm guessing the Delta variant is to blame here.
Yeah, of course. It's the Delta variant. All of this is because of Delta, and it's mainly affecting the unvaccinated. And if we look around the country at places that are being overwhelmed, we first see a jump in adult cases and hospitalizations. Then we see the same in kids. Right now, Rainbow is full of kids with RSV, a respiratory illness we typically don't see until late fall or winter. Hospitals nationwide are dealing with this. The concern, there's no room for more kids if Delta becomes a bigger issue. Doctors on the front lines are adamant that we all need to protect the most vulnerable. If they can't be vaccinated, a mask is the next best thing.
We have to protect the vulnerable population until they can be vaccinated. It is our moral obligation as human beings to protect our children. Every person in this state should wear a mask at all times when they are outside their home.
Boy, she can't be more plain than that. Dr. Edwards says we have the data that masks work in reducing transmission in the classroom from last year. So that's the best place to start, which is exactly what the Ohio Department of Health and the CDC recommend. But her concern is this variant is so contagious, she hopes that will be enough. Regardless, she expects to see an upswing in cases in the next few weeks after kids return to school, but she hopes she will not be seeing any of them in her ICU.
Yeah, it's scary stuff, but I think a lot of parents are questioning this and talking about this. You know, should my kids mask, should they not? Also, is the Delta variant more dangerous for kids?
You know, according to the American Association of Pediatrics, about 1% of kids who get COVID get hospitalized, and at least 350 kids died nationwide, 7 in Ohio. However, with Delta surging, the age of the hospitalized is starting to skew younger. And according to the CDC, between July 31st and August 6th, children with COVID were being hospitalized every day nationwide. That's nearly matching 217 daily admissions during the pandemic peak in early January. In Ohio, we've seen our child cases jump since June. We've had more than 2,400 cases in the first 2 weeks of August. So far, though, fortunately, and let's hope it stays this way, we don't have a lot of pediatric COVID cases right now in our local hospitals.
Let's hope it stays that way. A quick clarification. We heard the doctor say if you're outside your home, does that mean if we're outdoors too?
You know what? I think every situation is different. We know if you're going to be in crowded conditions, yeah, it's just a good idea, especially if you're not vaccinated or you have somebody at home who can't be vaccinated, like a child.
Sure.
But otherwise, yeah, outdoors, we know the transmission was a lot easier. But again, she goes on to say this variant is more contagious than anything they've ever seen. And she told me, she goes, you just don't understand how contagious this is.
Yeah, it must be because these numbers are ramping up dangerously fast.
Yeah.
Monica, thanks.
Sure.
And as we just heard from Dr. Amy Edwards, masking is really the way to go here. But not everyone feels their kid should wear a mask while sitting in the classroom. The mixed bag of policies across the state is causing some serious frustration for parents. Our Lindsay Buckingham reports.
There's a mask battle going on between parents and schools. Last night in Brecksville, Broadview Heights, some were fighting for freedom.
Huge concern with somebody deciding the health and safety of our children. Please don't do that, because then I will get upset. Please be fair.
Others fighting for protection.
Let's show our kids how to live the BBH code of conduct through the safety of simply wearing a mask.
Districts across Northeast Ohio releasing varying plans on masks, many requiring them indoors, while others recommend but don't mandate. That's something 14-year-old Finn Wilburn, a vaccinated freshman at Hoover High in North Canton, doesn't agree with. So tonight, he's speaking up at a board meeting.
We're all part of this community, and there are thousands of kids who cannot get vaccinated, as I've said before, and it's our duty to protect them. It's the board's duty to protect them by requiring that they wear masks.
And in Bay Village, parents divided over the district's plan to implement masks for the first 2 weeks before reevaluating based on the county's case data. With planned protests for parents on either side, the district said in part, with the Delta variant and its increased spread, we are choosing to be proactive. But at the center of each side are the kids whose parents, despite their views, are trying to do what's best for them.
We just want the choice to let our kids choose and let ourselves choose for, our smaller ones, like whether they want to or not.
And we reached out to the Ohio Department of Education to ask about its guidance to Ohio schools. In a statement, the department said it refers school leaders to the Ohio Department of Health's guidelines, which recommends schools require masks. Laura?
All right, this is a hard one. A lot of opinions, a lot of passionate parents. Lindsay, thanks so much.
You bet.
And today, the CDC strengthened its recommendation for pregnant women to get the COVID vaccine. The CDC says scientists analyzed safety data involving nearly 2,500 pregnant women who received an mRNA COVID-19 vaccine before 20 weeks of pregnancy. They did not find any increased risk for miscarriage. The agency also says that pregnancy increases the risk for severe illness from COVID-19. This also includes those who are breastfeeding, trying to get pregnant, or might become pregnant in the future.
Well, Laura, he's famous for being the first man to walk on the moon. That happened, of course, back in 1969. Today, to honor the American hero, NASA Plumbrook in Sandusky was renamed the Neil A. Armstrong Test Facility. Members of Congress, as well as Neil's son Mark, were all at the naming ceremony today. The testing facility is pivotal in our return to the moon. That's where they do the testing of the Orion spacecraft for Artemis 1, which is an unmanned mission around the moon. Neil Armstrong's son thinks it's a fitting tribute to Dad.
Maybe whereas Dad may not have wanted his name attached to something just because he didn't feel like he deserved that, honestly. The family, in retrospect, is thrilled.
Yeah, you can tell Mark is excited about this, and he's absolutely right. Neil was such a humble man, such a simple man, brilliant, but very humble and simple. And I think he might blush a little bit about this, but at the same time, it's such a great honor. And it really is pivotal in America's current space age. They're testing things out there all the time. I grew up in Sandusky, and I always remember you could always tell when they were testing the rockets because you could hear the dishes in the house rumble just a little bit. Yeah, we were very close to it.
Right in your backyard.
Now, I'm not in my backyard, but within a few miles, just a few air miles, you could feel the ground tremble when they were testing certain rockets. It was kind of cool.
That's really cool, and it's such a big deal also for this area.
Yeah,
it is. It's so powerful.
It makes us feel connection. When we turn on the TV and we see a rocket that's going, even if it's unmanned, heading to moon, we played a small part in that.
And you're from Sandusky, that's pretty cool.
That's kind of cool.
Yes,
I like it. All right, next on What's New, the Summer Olympians are returning home from Tokyo. I sat down with Westlake native Adelaide Aquila to talk about her shot put experience overseas.
Then a new cast is out who's taking top spot characters in the upcoming production of How I Met Your Father. That's coming up in Pop Break.
And we say hello again to Matt Wintz. So, Matt, I'm wondering, Indians game in play or what?
Yeah, we've been talking back and forth with them. I think Indians are going to be a go. There'll likely be a delay. This storm is going to get through here, and it's getting through fast. Your outdoor dining not looking good this evening, obviously. We'll fall back into the 70s. Just had a report of near 80-mile-per-hour winds in Bay Village. I just tweeted about it. We've got that update. We'll talk